Good afternoon, everyone. Welcome. It's a great pleasure to welcome you to the renovated Guthart Theater. So hopefully you've been here before, Presidential Symposium and other events, but we have more seats, much more comfortable, and other than having to find our way to walk around the back to get up on the stage because I might pull a hamstring if I jumped up, this is all working very, very well. So my name's Charlie Reardon. I serve as provost at Hofstra, and it's my great pleasure to welcome you to the 2025 Fall Distinguished Faculty Lecture. So just a little bit of history of the lecture. I'll introduce our distinguished speaker, and then we'll get right into it. So in 1981, the university actually inaugurated the annual Hofstra University Distinguished Faculty Lecture Series, obviously to recognize the outstanding excellence that is our faculty here at Hofstra. For the past quarter of a century, we've upped that to 2 lectures per academic year, one in the fall, one in the spring, often focused on either scholarly or pedagogical innovations. And this fall's lecture continues that tradition with the focus on constitutional law. This afternoon's lecture will be delivered by Professor Eric M. Freedman, the Siggi B. Wilzig Distinguished Professor of Constitutional Rights in our Maurice Deane School of Law. Professor Freedman, a part of our Hofstra community since 1988, is recognized nationally as a leading scholar of constitutional law and of history. His work explores the enduring principles of our democracy, from the First Amendment and the separation of powers to the rule of law and the struggle for justice in capital and habeas corpus cases. Professor Freedman is a Fulbright scholar, a Yale Law Journal editor, and a life member of the American Law Institute. He's the author of several influential books, including Making Habeas Work, A Legal History and Habeas Corpus, Rethinking the Great Writ of Liberty. His work has shaped national discussions on capital punishment and the scope of constitutional rights, and continues to do so to this day. Professor Freedman has received numerous university and professional honors, too numerous to list, of course, here. I'll refer you to his CV, but just to highlight, he has been honored as Hofstra's Professor of the Year on 4 different occasions, the John DeWitt Gregory Research Scholar Award recipient, and multiple Public Interest Achievement Awards from the Hofstra Public Justice Foundation. In fact, this is his 3rd distinguished faculty lecture at Hofstra, the prior 2 having been delivered in 1992 and 2017. And I encourage you to go back and look in the history of the 1992 lecture and the topic. Think about where we were in 1992 and where we are today. The topic had to do, in a post-Nixonian context, the invincibility of the unitary executive. Those are my words, not his. So today, Professor Eric M. Freedman is going to deliver the 2025 Distinguished Faculty Lecture, which is entitled, No Need to Wait, Congress has the Power Today to Abolish the Death Penalty in the States. This is a topic that reflects Professor Freedman's lifelong commitment to justice, history, and the enduring promise of our Constitution. And I personally look forward to learning about his thesis that the Constitution, through its Bill of Rights, provides a path to eliminate state-level death penalties. Please join me in welcoming our distinguished colleague. Thank you so
much. Thank you so much, Professor Reardon. I have as my goal for this talk that when I'm done, they don't amend the rules to put a cap of 2 on the number of distinguished lectures that can be given by any one person. And I really need to start by thanking the real heroes behind this project. My reference librarian, Isaac Samuels of the Hofstra Law Library, who's available around the clock to provide research support, and my wife, Melissa Nathanson, who's available around the clock to listen to my inspired and not so inspired ideas. I've been trying to figure out how to make this talk on a legal topic less boring for those of you who don't think it's recreational reading to read law review articles that run to 60 pages and 277 footnotes, Although for those of you who do think that, there are copies on the back table. But for the rest of you, I thought I would start with the legal equivalent of Chekhov's gun. The playwright Chekhov said that if your play has a gun hanging on the wall in the first act, you should make sure that it is fired by the end of the first act, and that's my plan. Only this gun is an obscure legal document that, as you can see, was stamped by an Alabama state court as received and filed on December 27th, 1999. So, with that to keep you on the edge of your seats, let me get started. The legal starting point, which is not controversial, although it's not well known to some members of Congress, is that Congress does not have the power to solve every social problem. In order to pass a valid statute, it must be exercising a power specifically granted to it by the Constitution. And the founding generation was very intense on that point, and that is why they insisted, as a condition of ratifying the Constitution, that it contain what ultimately became the 10th Amendment. And that says, quite explicitly, that the federal government has only the powers granted to it by the Constitution. Now, following the Civil War, the federal government gained a number of powers. The Civil War amendments to the Constitution, 13, 14, 15, were all designed to keep the states from oppressing their citizens in various ways. And each of those amendments, for the first time, ended with a section saying that Congress has the power to enforce the provisions of this amendment. And the 14th Amendment works just that way. It first says that no state shall deprive any person of life, liberty, or property without due process of law. And the Supreme Court has long interpreted that to mean that the states are bound by the provisions of the Bill of Rights. And then Section 5 of the 14th Amendment says that Congress has the power to enforce the amendment by legislation. So my idea is that Congress would have the power to pass a statute abolishing the death penalty in the states. It would be a very simple one-sentence statute, but I wrote out the whole sentence for the benefit of Professor Sample's federal courts class. There's only one minor problem. The power that Congress is supposed to be exercising when it abolishes the death penalty in the states is the power to enforce the Bill of Rights. But the Supreme Court has held for almost 50 years, and certainly isn't about to change its mind anytime soon, that the states do not violate the Eighth Amendment, which abolishes cruel and unusual punishment, by having a properly structured death penalty system. So how can a statute forbidding the states from having a death penalty claim to be enforcing the Bill of Rights? Well, that issue has arisen before, and there is a quite solid line of Supreme Court cases addressing it, running from 1965 right through 2023. In 1959, the Supreme Court ruled in a case called Lassiter versus Northampton that it was not unconstitutional for a state to have a fairly administered English language literacy test as a qualification for voting. But in the Voting Rights Act of 1965, Congress banned such literacy tests for people who had been educated in Puerto Rico. So the state of New York brought a constitutional challenge to the power of Congress to enact that portion of the Voting Rights Act, and the state quite straightforwardly said, Congress can hardly claim to be enforcing the Constitution by forbidding us from doing something that you held just a few years ago we're entitled to do. And in a case called Katzenbach versus Morgan, the Supreme Court rejected that argument. And what they said was, it would make no sense to say that the only statutes Congress could pass under this power were ones preventing the states from doing something that we've already held to be unconstitutional. States can't do those things anyhow. We aren't going to read Section 5 to confine the legislative power in this context to the insignificant role of abrogating only those state laws that the judicial branch was prepared to adjudge unconstitutional. Section 5 is a positive grant of power to exercise its independent judgment as to what is needed to enforce the guarantees of the Bill of Rights. And so here in Katzenbach versus Morgan, Congress could very reasonably have found that English language literacy tests needed to be abolished with respect to the Puerto Rican community in New York to protect that community's right not to be discriminated against in the provision of government services. And a good example of that, working as it should, is a case called City of Rome, which was decided in 1980. The Constitution outlaws only barriers to voting that the states erect with a racially discriminatory intent. But the Voting Rights Act sweeps more broadly and outlaws barriers enacted with a racially discriminatory effect. So the City of Rome, Georgia, brought a lawsuit very similar to the one that New York had brought. It said the Constitution wasn't being enforced by the congressional statute and was invalid. And again, the Supreme Court flatly rejected the challenge. And in June 2023, much to the surprise of Professor Sample, the court specifically cited this precise passage in a Voting Rights Act case and reaffirmed that rule. And the rule is this. Congress has the power to create a statute, red circle, that is broader than the core constitutional right, center circle, as a prophylactic rule in order to make sure that the core right is upheld. Congress can safeguard against the risk the states will violate core rights. But there is an outer limit here. Congress does not have the power under Section 5 to enact statutes represented by the blue circle, ones which are so far from the core that it isn't enforcing or protecting a constitutional right, but rather creating a new one. And the court articulated its test for telling the one sort of statute from the other in 1977. The congressional statute has to be congruent and proportional to the constitutional injury sought to be remedied or enforced, granting Congress a wide latitude of judgment. And the court has had many cases since 1997, and sometimes they've ruled that a federal statute passes this test, and other times that it doesn't. And what we learn from those cases is that the closer the problem Congress is addressing is to one or more areas that have historically been of fundamental constitutional concern, and the stronger the empirical record regarding the need for remedial or preventative action, the broader is congressional power under Section 5. And in this regard, it's relevant that prior, less aggressive actions by Congress to solve the problem have failed. So now we come to my proposition that it would be constitutional for Congress to pass a statute abolishing the death penalty in the states. My argument is that it would be a congruent and proportional response to at least 7 well-documented ways in which the states are violating core constitutional rights. And I would just point out, before I begin listing them, that in some of those instances, you may think that a more narrowly drawn statute would solve the problem. That may be true, but it's not the test. The test is whether abolishing the death penalty is a solution that Congress could reasonably believe is congruent and proportional to remedy and prevent the violation, even if Congress might have chosen some narrower solution. So I will list my 7 constitutional violations and give a bit of background on each, but bear in mind that Congress is entitled to view them holistically. The violations act synergistically to exacerbate each other, as we will see, and the court has said in the context of a statute to fight gender discrimination by the states, that where you have mutually reinforcing stereotypes and it's difficult to detect whether they are operating in any particular case, congressional power under Section 5 expands accordingly. So here are the 7, and I will be happy to go into great detail about any of them afterwards. But the point for the moment is that Congress would have ample empirical evidence to conclude that each one of them is a serious problem with the state's capital punishment systems, so that a congruent and proportional response would be to abolish those systems. 1, denial of effective assistance of counsel in capital cases. The duty of the states to provide such counsel was one of the very first ones that the Supreme Court recognized under the Due Process Clause of the 14th Amendment. That happened in 1932 in a case called Powell versus Alabama, one of the cases known to history as the Scottsboro Boys cases, in which a number of innocent young black men were wrongly sentenced to death for the alleged rape of a white woman. And they make the obvious points about the need for counsel, which I've compressed for you in the first quote on the screen. But there is another non-obvious one that they cover in the second paragraph and that you need to bear in mind. This is like surgeons burying their mistakes. Attorney incompetence tends to conceal other defects in the case. So, for example, if the client has mental impairments, that may be a basis for attacking a confession, or be a pitch for mercy, or even, as we'll be coming to, preclude an execution altogether. But if an incompetent attorney fails to investigate the client's mental condition, then no evidence of it will ever exist. We don't know what we don't know. But the unfortunate real-world problem is that the Supreme Court's constitutional test for determining whether trial counsel was competent is laughably weak and has been condemned in dozens of law review articles, bar reports, and judicial opinions, as you can find at note 68 of my article if interested. Under Strickland versus Washington, decided in 1984, a prisoner who claims trial counsel was ineffective has to show 2 things. First of all, unprofessional performance by counsel. Well, that would be fine if they did not then put a heavy counterfactual thumb on the scale. As you can see, there is a strong presumption that every failure by the trial lawyer wasn't actually a failure at all, but a strategic decision. If the prosecutor's sister sits on the jury and the lawyer fails to challenge this, we will indulge the presumption that the lawyer did this for strategic reasons because he didn't want to upset the prosecutor, who might still be in a position to offer a plea bargain before the jury comes back. And the second part is prejudice, meaning a reasonable probability that the outcome would have been different. Very frequently, the courts say, well, this was a terrible crime, and the prosecution's case was overwhelming as to both guilt and sentencing. It would have made no difference what the defense lawyer did. But remember, we don't know what we don't know. The record on which the court says that is commonly the one compiled by that self-same ineffective lawyer. So the Supreme Court's substantive rule lets lots of ineffective performance go uncorrected, which is exacerbated by a series of procedural obstacles. The prisoner's ultimate goal is to get to the third column, to assert on federal habeas corpus that his or her federal constitutional right to the effective assistance of counsel was violated at trial or on direct appeal where the same standards apply. And in doing that, the prisoner is invoking the Habeas Corpus Act of 1867, which is now 28 U.S.C. 2254, but whose core hasn't changed. And the core, which Congress enacted under Section 5 right after the Civil War, is that a prisoner can file in federal court an application for relief, known as a writ of habeas corpus, saying, quote, he is in custody pursuant to the judgment of a state court in violation of the Constitution or laws or treaties of the United States. But to get there, the federal habeas corpus statute says that the prisoner has to exhaust any state post-conviction remedies, the idea being that the state should have the first chance to fix any constitutional errors. That's the middle column, column 2. The problem is that despite the best efforts of some of us, the Supreme Court does not recognize a constitutional right to effective counsel at state post-conviction. Yet, the federal courts will not consider any errors that were not raised there and raised in accordance with state rules. So the system works only one way. The lawyer in that middle column may forfeit the prisoner's right to be heard in federal court, but the prisoner may not attack the lawyer as ineffective for having done so. And if you want to know why that is so, this is what the Supreme Court said in a case where the federal courts refused to hear any claims by a prisoner because the state post-conviction lawyer had filed the appeals papers 3 days late. The explanation is that this outcome reflects, quote, the appropriate allocation of costs as between the state and the petitioner, period, close quote. And the prisoner was executed a few months later. So, Congress, in several statutes, in 2004 and 2006, has sought to give the states incentives to provide competent counsel on state post-conviction. No state has done so. They like this system fine. Now, if the prisoner does get to federal court to present federal claims, there will be a whole set of obstacles to vindicating those claims, as we'll see. But the most serious one, for present purposes, where the ultimate claim is going to be a claim of ineffective assistance of trial counsel, is that the federal court is only entitled to consider the record made on state post-conviction, where you will recall there was no right to effective counsel to document the claim. So, if Congress were to conclude that despite its best statutory efforts, the states had utterly failed to assure the effective assistance of counsel at trial and on appeal in capital cases, that would certainly be a soundly based conclusion. And if Congress were to conclude, in light of the pernicious nature of attorney ineffectiveness in concealing other defects in the state's case, that the congruent and proportional response would be to pass a statute forbidding states from having the death penalty, I think that would be well within its Section 5 powers. Next constitutional violation that Congress could find. Racial discrimination in the selection of capital jurors and in charging and sentencing decisions. And the Supreme Court has been intense about this ever since the Civil War. Here you see them saying in strong language, in a case involving the exclusion of blacks from jury service, which Congress had made a crime, that Congress has been granted the power by Section 5 to eliminate racial discrimination in the judicial system. But it persists on a widespread basis, especially in capital cases. And there are two subpoints on this for now, and we'll be hearing more about race later. First, it is normal practice in a criminal trial to give each side a certain number of what are called peremptory challenges or strikes, which is the right to eliminate some members of the jury panel without needing to state any cause. And in a whole series of cases, from 1965 onwards, the Supreme Court has held that it is a violation of the Constitution for prosecutors to use their strikes to remove racial minorities from juries. But those rulings have not succeeded in eliminating the practice, so much so that a number of states have felt the need to adopt stricter standards by state law, which of course does nothing to vindicate the federal right. And there's a related point that Congress could certainly be aware of, although the Supreme Court refuses to fix it. And this is known as death qualification. A death penalty trial proceeds in two phases. The jury first decides guilty or not guilty, then it decides death or life. And people who could never vote for death are, of course, properly excluded as jurors from the second phase. But the problem in every state is that they are also excluded from the first phase. That is, people who are opposed to the death penalty are prevented from deciding guilt, which they could decide fairly. And the result of that, as you can see in dozens of studies cited in Note 260, is a jury that is heavily skewed against racial minorities as well as other marginalized groups, simply because those groups have been historically more likely to oppose the death penalty. And they also happen to be the groups most likely to be skeptical of the government's case on guilt. And so in capital cases, you have a jury more likely to find the defendant guilty in the first place than would have been the case if the prosecutor had not decided to seek the death penalty. Second, under the race heading, is the well-documented fact that capital sentencing is racially biased. As we said, in capital cases, juries impose the sentence. And innumerable statistical studies show that holding all else equal, race plays a very significant role. The death sentence is much more likely to be handed down in a case where the victim is white, and also much more likely to be handed down in a case where the defendant is black. And if both those things are true in the same case, the odds of a death sentence go up astronomically. And more recent research shows that the same holds true with respect to executions as well as to death sentences. Now, in McCleskey, a 5-4 opinion by Justice Powell, which he later said he regretted, the Supreme Court rejected a constitutional attack on that sentencing pattern. But it invited Congress to respond. And that certainly supports my view that Congress has the power to do so. And in light of the persistence of the problems, as well as the other racial issues we'll be coming to, I would say that abolishing capital punishment is a congruent and proportional response. Next. Back at the beginning, I said it does not currently violate the Eighth Amendment for the states to maintain properly structured death penalty systems. And what I meant by that phrase was this. In 1972, in Furman versus Georgia, the court considered a system in which a large number of murders in the state were eligible for death sentences. Prosecutors pursued capital punishment in a subset of the cases in which it was available, and juries imposed it in a yet smaller subset. And the upshot was that approximately 15 to 20% of the initially eligible defendants wound up being sentenced to death, and there was no culpability-related explanation to explain why people landed in one group or the other. The Supreme Court invalidated that system under the Eighth Amendment because getting a death sentence under that Georgia statute was cruel and unusual in the same way that being struck by lightning is cruel and unusual. Then in 1976, in Gregg versus Georgia, the court looked at the face of Georgia's successor statute and concluded that it sufficiently met those concerns. But that decision was not based on any empirical experience with the statute in question. And once the statute actually went into effect, studies showed that the outcomes were just as arbitrary as before. And the same pattern has been found in state after state. The statutes are incredibly broad in the categories of murders they make eligible for the death penalty, which is itself a violation of Freedman. And that problem has been getting worse over time as states keep adding new categories of capital crime. So, in that situation, the prosecutors have to exercise discretion to decide which cases they will actually pursue as capital, and different prosecutors do that in different ways. Now, it may be that they choose in racist ways, or it may just be that different prosecutors have different views about what makes this particular murder one of the worst of the worst. But at the end of the day, looking at the statewide results, you cannot say that the most heinous murderers were the ones who were prosecuted capitally or sentenced to death, much less actually executed. And that problem is growing steadily worse because death penalty prosecutions are dwindling throughout the country. In 2024, there were only 6 death penalty prosecutions in the entire state of Texas. So even where a state still has the death penalty, what that really means is that a tiny number of counties pursue it and the others don't. So whether you are prosecuted capitally depends on the county in which you happen to commit the crime rather than anything having to do with how bad the crime was. And that is a flat Freedman violation. And for Congress simply to outlaw the death penalty in light of this record would be a straightforward implementation of the Eighth Amendment in a context where the death penalty is growing increasingly unusual. So, now we are on to mental impairments, and there are 2 groups of people that the Supreme Court has squarely held may not be executed under the Eighth Amendment. First, A is the group of intellectually disabled individuals which the court previously called mentally retarded. And the prohibition on executing that group is based on the various considerations you see in the slide, quoting from the Atkins case which established the rule. Not only are they less morally culpable, but there are a whole series of reasons why their disability may hinder the judicial system from coming to an appropriate outcome in their cases. The problem is that the record of the states in implementing this rule has been appalling. So much so that the Death Penalty Information Center has a list of almost 30 prisoners who have been executed, even though they very likely were intellectually disabled. And that appalling record reflects a variety of factors, including the absence of effective counsel at trial level, the hostility of many states to the rule, as well as the inherent problem of distinguishing between intellectual disability and other mental conditions in a death row population in which mental illness is prevalent and dementia is increasing. But the federal courts can't effectively solve this because the Supreme Court can only take so many cases, and the lower federal courts are severely constrained in their review of state court adverse findings of intellectual disability by a federal statute known as AEDPA, which we will be discussing. So Congress would be warranted in abolishing the death penalty simply because Atkins is being violated wholesale. But remember the bottom line of Atkins, which I hope you can see in red. People with intellectual disability, in the aggregate, face a special risk of wrongful execution. So there is a substantial chance that every execution in violation of Atkins is an execution in which some other flaw in the case, like innocence, went undetected. And that certainly justifies abolition of the death penalty as a prophylactic measure. Now, moving on, the second category B under execution of the mentally impaired is this. The common law prohibited the execution of the insane. So the court held in the Ford case in 1986 that capital defendants who lack a rational understanding of the reason for their impending execution can't be executed. But again, there are serious compliance problems, which you can find documented in a series of studies cited in note 133 of my article. And those problems arise from several factors. Some we've just discussed, like the confounding effects of mental illness and dementia. And some are unique to this area. One very practical one is that a Ford claim can only be brought on the eve of execution, which is a context in which the courts are heavily disposed to deny the claim. But the more conceptual problem is that the very subject of the inquiry is nebulous. It is common in these areas for the experts to agree that the defendant is profoundly delusional, but to disagree on the precise contours of his delusion. So, in the most recent case, Madison, the Supreme Court wrote that delusions come in many shapes and sizes and remanded for the courts below to make the precise decision that Panetti requires. Well, that was a reference to the Panetti case you see on the slide, which was decided in the Supreme Court in 2007 and then resulted in 2014 in a stay of execution from the Fifth Circuit on the day he was supposed to be executed. In that case, Scott Panetti represented himself at trial in 1995, dressed in a cowboy suit, and tried to subpoena Jesus Christ and John Kennedy. He was held to be competent, even though by that time he had been hospitalized repeatedly for delusions and psychotic episodes. But that was a trial, and eventually when he faced execution, he was allowed to go forward on his Ford claim. And you would have thought that someone with a record like that would have had no difficulty in making out the claim. No such luck. The case was still being litigated in federal district court in the fall of 2023. All the experts agreed that Panetti was severely delusional, but they disagreed on how closely those delusions related to his understanding of why he was being executed. And the conclusion of the story was that he died of natural causes this past June without any final resolution of that issue. So remember this. There is a core group of insane people whom it is squarely unconstitutional to execute. But identifying individual members of that class is very difficult, and the consequences of error could hardly be more serious. One more support for a prophylactic rule abolishing executions. Okay, on to number 5. And what this fancy title means is that there are a series of legalistic obstacles that a death row inmate has to surmount before a federal court will even consider the merits of his or her constitutional claim. And we talk about those obstacles in 3 groups, starting here with A. And this group has to do with errors made in state court, especially in post-conviction proceedings in state court, where, remember, you are not entitled to the assistance of competent counsel or, in fact, to any counsel at all. Still, as we've mentioned, missteps there mean that when you get to federal habeas corpus, the federal court won't even look at whatever constitutional attack you have on your conviction. So 2 stories to illustrate this. In 1977, when Michael Smith was tried on capital cases in Virginia, he was interviewed by a court-appointed psychiatrist who, without warning him of his right to remain silent or have counsel present, elicited damaging admissions about the circumstances of the crime and testified to them at trial. And in 1981, the Supreme Court held that exact state practice in that exact state to be unconstitutional. So you would have thought that Smith had a pretty good federal habeas corpus petition. Not so. Recall this slide. In this case, counsel objected to the admission of the testimony at trial. But on direct appeal in column 1, counsel omitted that claim. And that was because there was existing precedent in the Virginia Supreme Court upholding the practice. However, the point was brought to the attention of the Virginia Supreme Court by an amicus brief from a clinic at the University of Virginia Law School. But it wasn't raised by a party, so the Virginia Supreme Court didn't consider it. After that, successor counsel raised the claim at every point, all the way to the U.S. Supreme Court. And when the case arrived there, the court, delicately citing the 1981 case with a CF, said, well, yes, the practice has been illegal for 5 years now, but you failed to exhaust the claim in state court. Now, it's true that that failure was on direct appeal, where you do have a right to effective assistance of counsel, but under our laughable standards in Strickland, there was nothing ineffective about what counsel did. Counsel on direct appeal is supposed to pursue only the stronger claims. Thus, quote, the defendant was represented by competent counsel, had a full and fair opportunity to press his claim in the state system, and yet failed to do so in violation of a legitimate rule of procedure. So he was executed the following month, even though he had been subjected to an unconstitutional trial. And I may add, even though you can be quite sure he didn't sit around editing whatever his counsel was filing. Now let's talk about John Eldon Smith. He and his wife, whose name was Rebecca McKetty, carried out a murder together. And they were tried in separate trials in the same county within a few weeks of each other, and both were convicted and sentenced to death. But she prevailed on a federal habeas corpus challenge to the underrepresentation of women in the jury pool that was based on a recent U.S. Supreme Court case. And at a new trial, she was sentenced to life, served 36 years before being released, and lived on for another 10 years until eventually dying of COVID in 2020. Now, he had been tried under that same jury system, and he also challenged it on federal habeas corpus. But his petition was denied. Why? His lawyers on state post-conviction were ignorant of the U.S. Supreme Court case, so they didn't assert the claim in the first state post-conviction petition. When they saw McKetty had asserted it, they filed a second state post-conviction petition, but the state court held that they should have put the claim into the first one. So he had committed a procedural default, and the state court refused to consider the merits. Then when Mr. Smith asserted the jury composition claim in federal habeas, the court held, because you committed a procedural default in state court, we will not consider the merits of your challenge. And that's a rule that the federal courts enforce with great intensity, as I elaborate at 1088 to 1091 of my article, but not one that Congress needs to accept. And that's especially true because it's being enforced within this framework where a prisoner has no right to effective counsel on post-conviction, but is bound by their errors. And remember, that framework exists because the Supreme Court won't find a constitutional right to effective assistance of counsel on post-conviction, and Congress has been unable by statute to get the states to provide effective counsel in those proceedings. So, in December of 1983, John Eldon Smith died in Georgia's electric chair, the first person executed under the Georgia statute that had been upheld in Gregg versus Georgia. The next group of legalistic obstacles to getting a federal court to hear a federal constitutional claim. In Teague versus Lane, the Supreme Court came up with a new interpretation of the federal habeas corpus statute. And that was that prisoners on federal habeas corpus were not entitled to the benefit of any new rule of criminal procedure announced after their convictions became final on direct appeal unless the rule was substantive. So consider Michael Odell. He was tried in Virginia in 1986. The prosecutor argued that he had to be executed because he was a danger to society, and the trial court refused to allow Odell to respond that if the jury rejected a death sentence, he would be sentenced to life without parole and never released. Well, in 1994, the Supreme Court held that a capital defendant did have the right to make that argument. But Odell's conviction had become final in 1988, so he was not entitled to the benefit of this new rule. As a result, he was executed in 1997, despite the agreement of all concerned that what had happened in his trial had been unconstitutional since 1994. The next set of obstacles was created by a revision of the federal habeas corpus statute that took place 30 years ago in a statute called AEDPA. Now, the real purpose of this act, which was successful, was to cut back on the extent to which federal habeas courts granted prisoners' claims that their federal constitutional rights had been violated. But that wasn't what the proponents said. They claimed that the state courts were entirely capable of upholding federal constitutional rights and should be given a chance to do it. Well, taking the proponents at their word, the states have had their chance and blown it, which is yet more justification for Congress to step in under Section 5. What the statute did was to add the three sections on the slide as limitations on a federal court considering a habeas petition. The federal court cannot exercise independent judgment respecting the existence of constitutional violations. It must, and the Supreme Court has been intense on this, defer to the state court's ruling against the prisoner unless the ruling was not merely wrong, but utterly unreasonably wrong on the law or the facts. In addition, AEDPA enacted a series of statutes of limitations to keep the federal habeas courts from ever reaching the merits. And as you can see at 1092 to 93 of the article, that has resulted in dozens and dozens of capital prisoners having their petitions dismissed without consideration of the merits. And the latest count is that 30 of them have been executed, sometimes in cases where the ruling was that the filing had been late by a single day. And you can find some dramatic examples in notes 208 and 210. Now, your deadlines for filing a federal habeas petition depend, for the most part, on events in your state post-conviction litigation, and very often the statute is blown because the prisoner has had an incompetent lawyer at that stage. But not necessarily, and now return to Chekhov's gun, which I know you have been waiting for impatiently all this time. This was a state post-conviction petition challenging the performance of trial counsel. And a month prior to the filing deadline, a courier from the law office handed the petition to the clerk and came back with a file-stamped copy. But the clerk's office later claimed not to have received it. So a couple months later, the lawyer himself went down to the courthouse and showed the clerk the file-stamped copy. And she said, yes, that's real enough, but we have no record of it. So he asked her how she handled such filings, and she pointed to a wooden box at the top of a file cabinet and said, I tossed them in there. So the lawyer walked over and behind the file cabinet found 3 petitions, one of which was his. End of problem. No, not at all. The original filing should have had with it a form asking for a waiver of the filing fee, but it didn't. If the petition had been properly handled, the clerk would have seen that, asked the lawyer for the form, and he would have provided it in plenty of time. But it was now too late for all that. State petition dismissed for non-payment of filing fee. And the EDPA statute of limitations required the state petition to have been timely filed, held all the way up to cert denied in the U.S. Supreme Court. Federal habeas corpus petition denied, no review of the merits of the underlying constitutional claim of ineffective assistance of trial counsel. So, looking together at all the barriers we've been talking about, I think it wouldn't be difficult for Congress to conclude that systematic obstacles exist to the vindication in federal court of the federal constitutional rights of capital prisoners, and we are safeguarding the rights of those prisoners by a statute preventing them from being executed. Next problem. This one is simple. Somewhat remarkably to any ordinary person, the Supreme Court has dithered as to whether the execution of an innocent person is unconstitutional. Or a bit more technically, if your only claim on federal habeas corpus is that you are innocent of the crime of which the state has convicted you, have you stated a federal constitutional claim? Well, Congress doesn't have to dither. The fact is that as of this moment, the legal system has acknowledged 201 wrongful convictions in capital cases since 1973. And in light of everything we have said to this point, it's a pretty safe bet that the actual number is higher. So how many innocent people have been executed without our knowledge? Well, you can apply statistical models to that question, but the fact is we don't know what we don't know. For purposes of congressional power under Section 5, it doesn't matter whether or not executing an innocent person is unconstitutional. Whatever you call it, it's certainly the ultimate failure of any criminal justice system. So the premise of a congressional statute abolishing the death penalty in the states would be that decades of experience show that our actual system of capital punishment does not have reliable procedures in place to detect, correct, and prevent the persisting danger that the states will wrongly kill their citizens. And if Congress had to defend that statute in court, it would call it prophylactic. If members of Congress had to defend it on the campaign trail, they would call it simple good sense. Okay, this point is also straightforward. No one doubts that the Eighth Amendment forbids methods of execution that cause unnecessary pain. But the Supreme Court has made it very difficult to vindicate that right. It puts a heavy burden on the prisoner to show that the state's method is sure or very likely to cause needless suffering, and remarkably, also puts the burden on the prisoner to identify some other alternative that is, quote, feasible, readily implemented, and in fact significantly reduces a substantial risk of severe pain. Well, first of all, Congress isn't bound by the restraints that the court puts on litigation. Those are litigation restraints, not definitions of the underlying right. But more broadly, this situation is a bit like innocence. Not all capital prisoners are innocent, but a significant and hard to identify group of them are. Not all executions inflict unnecessary pain, but a substantial number do. And we know that from repeated studies, not only by scholars, but by the states themselves, which have kept reviewing and changing their methods in a trial and error approach to overcoming the problems that have resulted in some truly grotesque spectacles. And beyond that, we again don't know what we don't know because the states have systematically imposed barriers to the public obtaining information about their methods. In fact, in the most recent execution in Indiana, which happened last week, the press was just flatly barred from attending. So a congressional ban on executions would be a well-justified prophylactic rule against the core constitutional violation of executions by torture. And I conclude my list of 7 by reminding you that in determining what is congruent and proportional, Congress can take a holistic view of the way in which these various problems exacerbate each other. Counsel issues make all the others worse, as do racism issues. Undetected mental impairments make execution of the innocent more likely, and so forth. All of which leads to the next question. No matter how convincing this is as a legal argument, isn't it politically impossible? And I would say difficult but not impossible. The overall situation is a little different than it may appear on a casual view. For starters, in 23 states, some of which, like Alaska and North Dakota, don't leap to mind as hotbeds of progressivism, the death penalty has been legally abolished. And there are another 10, some of which, like California, Pennsylvania, and North Carolina, have quite large death rows, where there have been no executions carried out in the last 10 years. And there's little realistic prospect that any significant number of executions will take place in those states in the years to come. So the 66 senators from those 33 states would be plausible supporters of abolition legislation. And even in those states, like Texas, Alabama, and Oklahoma, where executions are currently taking place regularly, it's highly misleading to view the matter from 30,000 feet. As I mentioned, the death penalty actually exists in only a tiny number of counties within those states. So the political implication, particularly in the House, is that there may well be members of Congress from the abolitionist areas of retentionist states who will vote for an abolition bill. Remember that in the whole state of Texas, there were only 6 death penalty prosecutions even brought last year, 3 of which came from the same county. And for the last 10 years in Texas, there have only been 4 verdicts a year returned statewide. So don't be distracted by the upsurge in execution. Recently, executions are a trailing indicator. The death penalty is dwindling away on the ground. Furthermore, abolition is becoming increasingly popular among self-identified conservatives. In fact, in a number of states like Ohio, Missouri, Kentucky, and Kansas, Republicans are leaders in trying to get the death penalty abolished, saying quite accurately, another failed government program, waste of taxpayer money. And even if the abolitionists knew that there was no current realistic prospect of getting the federal statute enacted, there might be good reason to introduce the legislation as a messaging and organizing vehicle, and in order to put pressure on the retentionist states to reform their systems lest the statute pass. And so to end with law rather than politics, this is a fight that the proponents can lose 100 times, but only have to win once. If Congress ever does pass a statute under Section 5 abolishing the death penalty in the states, it will not have the power under Section 5 to pass a statute restoring it. Thank you for your endurance.
There we go. We'll open up to questions, and if you have a question, please come to the microphone so you can be seen and heard. Please go.
Professor Freedman, good afternoon. I wanted to know, to get your opinion, if you think exile would be a viable, constitutionally speaking, whether exile is a viable alternative to execution or even incarceration in terms of the Constitution.
I believe that it was long ago ruled that the answer to that question is no. And there may be some capital defense expert in the audience who can immediately come up with the name of the case. The most recent iteration was something called Afroyim versus Rusk, which had to do with denaturalizing you so they could deport you. But there's a much older one in which they held, no, you can't just throw them out of the country. It's your problem.
Thank you.
Wondering, in terms of, you said that Congress can consider holistically the 7 violations that you described. I'm wondering, in terms of looking to craft a statute that passes the congruence and proportionality test, what evidence do you think would be most persuasive for them to compile in that record?
Well, not so subtly, that's why I really wrote the article, right? And it says so at the beginning. It says, the purpose of this article is to show that there is an extensive empirical record which could be used under each of the 7 points. And it even says, and all I'm doing, even though I write a, one-page footnote, is giving you a sampling of dozens of studies which show the same thing. And I apologize to all my colleagues whom I didn't cite, right? The answer is that in order for this to really pass Supreme Court muster, as we know from Voting Rights Act cases and others, Congress would absolutely have to compile at hearings a very, very full empirical record. But my argument is they could do that. There exist more than enough studies so that the even the Supreme Court would have some trouble saying, as they do sometimes, Congress didn't have sufficient evidence on this particular point. And that goes particularly because, as I said, where the thing that we are trying to prevent or remedy is a core constitutional concern, and where Congress has tried to fix it and the problem persists, and where detecting individual instances is difficult, those are all reasons why Section 5 power is stronger. And I think my pragmatic political answer is, if this Congress, or if any Congress and the president manage to get their act together to do it, the Supreme Court is not going to throw itself in front of that truck on something which is not core to the Republican agenda. And it's, in a way, it's sort of like Obamacare. They're not, something that has enough popular oomph to go through is not likely to be invalidated in the face of a strong empirical record. And that's exactly the conclusion of the article is, if Congress manages to pass it, Supreme Court will uphold it.
Thank you.
Hi again. Is there a constitutional argument to be made that execution is per se a cruel and unusual punishment? And if so, what is it?
There is, but it's been rejected repeatedly. And it relates to evolving standards of decency. Even Justice Scalia said, my job is to look around and decide whether a punishment is cruel and unusual. So if lots of states had whipping, which I think is a horrible thing, but if they had it, that's fine. But if it gradually dwindled out to the point where only 1 or 2 states had it, I would say it's cruel and unusual, and I would invalidate it. Well, that's what we're talking about. We're talking about a small and dwindling practice in the states of the Old South, which, even if you don't believe what's currently the framework of evolving standards of decency, right, the trend of the states to abolish it, but even if you just look at how often the practice is in fact inflicted, you could, without getting into profound moral arguments, say, yeah, it's cruel and unusual, it goes.
Thank you.
Oh, thank you, Professor Freedman, for a fabulous, persuasive lecture on a very grim topic. This goes back a little bit to the last question over here, but I'm curious, when the audience for the piece, how much are you thinking about, I suppose, is the Shelby County case for this statute down the line, and speaking to Congress to create a record for that case on the one hand, and if so, what does that scenario look like for you? I would imagine Texas AG, for instance, bringing a 10th Amendment claim to the statute. And then on the other hand, how much are you thinking about public persuasion or even political persuasion of Congress? Just to say that I think your presentation both establishes a persuasive legal argument, but I think policy-wise is very powerful in terms of showing, I think, as you said, that this does not make good sense. So are you thinking about both aspects of that with the piece?
Yeah, the answer is all of the above, and I thank Professor Loris Cohn for enabling me now to put back in something which I cut from. The obvious historical analogy here is to anti-lynching legislation. Anti-lynching legislation was introduced for the first time in the U.S. Congress in 1900. It was defeated 200 times in the intervening years, but during those years, the NAACP got a lot of press value, the states felt themselves under pressure, and the Supreme Court became much more sympathetic to the problem, as the Harvard Law Review noted in 1928. So the campaign itself had a lot of benefits. And then, lo and behold, 100 years later, 122 years later, in the wake of the George Floyd case, the Emmett Till anti-lynching bill passed in 2022 with huge bipartisan support, was signed by President Biden on the White House lawn because the confluence of messaging, public support, political acceptability made it possible to happen. So, again, the answer to your question is all of the above. But in the Section 5 context, everybody was behind the Violence Against Women Act. That didn't do it without an appropriate empirical record. It's critical to cover that piece of it, too. All right. Thank you so much.